So, welcome to Regulation Central, everybody. I'm Robbie Chrisman. Looking forward to the next 45 minutes. We have Mr. Richard Horn on, who's going to help take us inside the CFPB, as well as usual panelists, Mr. Peter Idziak from Polunsky Beitel Green, Brian Levy, and Loretta Salzano. And I only say Polunsky Beitel Green rather than Brian's firm or Loretta's because they are our lovely sponsor. Check them out at mortgagelaw.com. I've been around more than 5 decades now. Can help you in a variety of ways. Uh, but let's dive right in. I'm actually loving this. Last time we got a comment like, I love that you guys don't do any small talk. Let's jump in. Brian, I'm gonna kind of let you moderate the first question, if you will. Let's launch into the CFPB, their policy culture, what's going on. Uh, we'll get into the recent Townstone case filing. We'll get into fair lending, but I'm going to kind of cede the floor to you on where you think a good place to start this discussion would be today, since we have
Yeah,
Richard.
thanks, Robbie, and I'm real excited to have Rich here with us. Being a former CFPB attorney, obviously one of the lead authors, if not the lead author, of the TRID regulation, and quite a bit of experience with fair lending and other things in the mortgage area. So I guess, Rich, I'm curious as to kind of what your reaction is to what you're seeing happen at the CFPB, the sort of I don't know what you would really want to call it in terms of this sort of shutdown mentality, do minimalist kind of approach that they're taking, do only what is required by the statute. I think that's the court order that they have now. Maybe if you could just sort of comment on what you're seeing, and then we can get into maybe some more details after I hear your first response.
Great. Well, first of all, thanks to you all for inviting me to be here to join this esteemed group of panelists. Brian, Loretta, Peter, Robbie. It's what a pleasure, and I think this is a great topic to talk about because for the mortgage industry, we are regulated by the CFPB, and so what's happening at the CFPB affects us. Yeah, and even if you're not subject to a CFPB exam currently, and you're not facing this kind of stop work order, you still are dealing with CFPB rules. So the fact that CFPB's had been shut down, its rulemaking function and other functions, I think still does affect everybody. Plus, I think looking down at the next 4 years, seeing potentially at what it looked like in February that there wouldn't be a CFPB in existence was definitely something I think was concerning to a lot of folks in the industry because industry likes regulatory certainty. You want to know who your regulator is and is going to be for the next 4 years. And so there was a lot of uncertainty and a lot of things to think about. There are still things to think about now. As you alluded to Brian, the the lawsuit against the CFPB acting leadership has been winding its way through the courts, and currently the CFPB is subject to a preliminary injunction that was issued by the DC District Court at the end of March, and then just recently, at the end of last week, was partially stayed by the DC Circuit Court of Appeals. And that preliminary injunction really does, even in its partially stayed form, can tie the hands of the acting leadership of the CFPB from actually trying to quote unquote delete the CFPB as Elon Musk, the head of Doge, had tweeted. So I don't think we're going to see anytime soon the CFPB completely dismantled and deleted. So, the other Elon Musk tweet, RIP CFPB, I don't think we need to start saying that just yet. Essentially, the acting leadership is not allowed by these court orders to do a wholesale termination or RIF of all of the employees, which it appeared from at least what the district court had found had been the plan of the acting leadership of the CFPB. There was according to the district court, a plan to have a reduction in force of the vast majority of the CFPB employees, and now that's been stopped by the courts under the partial stay partially stayed preliminary injunction, if the acting leadership wants to do a reduction in force, they actually have to do what the court described as a it's even hard to say, particularized assessment, that those employees that they're essentially riffing or reducing in force are unnecessary to the performance of the CFPB's statutory duties. So what the court's saying is, okay, you can do a reduction in force, but you really have to do some kind of assessment to make sure that those employees that you're letting go aren't going to affect the CFPB's ability to perform its statutory functions. I think what counts as a particularized, again, hard to say, I should have practiced this before the webinar, particularized assessment. It's an open question. The court didn't provide any, check mark, check the boxes types of things that the CFPB has to do that assessment. So it could lead to another lawsuit if the CFPB did do that type of assessment and rift vast majority of the CFPB employees. That could lead to essentially more litigation on whether that actually was quote unquote a particularized assessment. And so I think that it does in effect in practice probably make it more difficult for the CFPB to completely dismantle the CFPB, plus other parts of the preliminary injunction are still in place, like an inability to rescind, to terminate all of the CFPB's contracts. Yep.
Sorry to interrupt. This is great stuff. A lot of detail. I think maybe we can come back to. And I want to welcome Matt. See, he's now joined us. Our fearless host here is back on. I'll turn it back over to him after I get this question in. But I
No,
really do.
Brian, I said, Brian, neither Matt nor I should speak the rest of the show, and I mean that. I'd like you four to continue. I'm serious. Please, please.
Be careful what you wish for.
Here we go.
So, no, I'm really curious to hear now, this is sort of what's going on in court, what
Right.
they have to do. And I'm curious as to your thoughts on, I'm maybe stepping back a bit and, sort of thinking about what you know about the culture at the CFPB, the nature of, the interactions between sort of the political people and the policy people, the more embedded people, career people, I guess. I don't really know what you want to call it. But I'm very curious as to your thoughts on, because I've seen some really interesting chatter coming out of just social media stuff where former CFPB people are kind of saying, hey, we were never really on board with a lot of the things that the CFPB was doing. We felt very isolated. We weren't being heard internally, particularly under Chopra. That there just really wasn't it was a very top-down driven kind of organization and culture. And I guess I'm curious as to what your thoughts are on that whole issue and maybe what this, where we end up culturally in a new CFPB.
Right. So I mean, that's a great question. I'll take I'll take it up a level. Apologize if anyone fell asleep while I was going through all the details of the court. But the issue for a lot of the employees, as you alluded to, Brian, has been, look, there are a lot of true believers there. That's what I like to call them. They believe in the mission, and that's come across from all of their employee surveys, and that information has been made public and has been reported over the past, years since the CFPB has been in existence. I think a lot of the CFPB's employees say, we believe in the mission, we really believe in what we're doing. And so I think a lot of them really are conflicted right now. They don't probably want to work for at least an acting leadership right now that views them as kind of the enemy. I mean, if you look at a lot of the statements from the current acting director, has described the agency as weaponized and essentially maligning all of its past work. And so I think that they probably bristle at those types of statements. And I do know that a lot of current CFPB employees are out there looking, at least testing the waters of the market to see if there's any other jobs out there. And so what that could end up leading to is a lot of good people from the Bureau. And these are even reasonable people who, while they believe in the mission, I wouldn't call them true believers like in the vein of Elizabeth Warren and Rohit Chopra. There are a lot of very reasonable, really good attorneys there who like to see all sides of an issue and think about that, particularly in my former office at the CFPB in the Office of Regulations, where where I led the TRID rule. I dealt with dealt with the industry quite a bit, and probably a lot of people in the industry saw. I was out there listening to what the industry had to say and developing the rule. And the vast majority of Office of Regulations attorneys there are the same way, that they do care about getting it right and listening to all sides of an issue. That's very different from the other offices of the Bureau. Office of Enforcement in particular, where you have a lot of aggressive attorneys who view their job essentially as trying to get the guy, and they essentially are persecutors and not prosecutors, and like to go after aggressive legal theories. And they are like the Rohit Chopra, Elizabeth Warren, true believer types who definitely are unhappy and most likely, looking elsewhere for
Rich,
work.
I have a question for the panel. Do you think that this, like you just stated, that the employees, some of them are on board, some of them are on board. Do you think that this goes back to a flaw in the core architecture of a single appointed director format, and that the employees may felt differently if we had more of a board format, which was proposed? But we obviously wound up with a single director, and we've actually rehashed this, going back through case law. Would that have been more beneficial to the swing employees of some are on board now, some are not, in your opinion?
That's a great question. I'm just going to finish one point on my last point. If a lot of good attorneys leave, and people who might join the Bureau have looked at the last few months and say, well, if I join this really politicized agency, I might get riffed at any point in time. I think what this whole last couple months could lead to, all this turmoil, is really less of an interest of good people wanting to join the Bureau. So unfortunately, over time, this could result in lower quality work coming out of the Bureau, which isn't good for the industry. I mean, to some extent, it's good that some people leave the Bureau or get fired from the Bureau. A lot of, like I said, a lot of their employees didn't really care about what the right answer under the law was, and were just extremely aggressive and really not following what the answers are, and trying to listen to all sides of an issue. But there are a ton of attorneys there who are good attorneys and very reasonable. And if we lose those people, then it really does, especially in the Office of Regulations, it's going to reduce the quality of the work and unfortunately the guidance and regulations coming out of the Bureau. So hopefully that doesn't come to pass, but that's definitely a possibility. And then onto your question, Matt, I think having a single director, especially in the early days, did lead to the hiring of a lot of those true believer types. So, back in the beginning of the agency, when Elizabeth Warren was effectively running it, and then you had former Director Cordray, you had a lot of people with that type of politics and mindset joining the Bureau. And the Bureau, I think, was viewed by a lot of those folks as not a federal financial regulatory agency, like a very mature agency like FDIC or OCC, but kind of like a consumer advocacy group with federal powers. Their view was the other agencies weren't aggressive enough, weren't doing enough, and so they wanted to be the antithesis to, maybe in some ways it was good, but to agencies like OTS and HUD and other agencies. So they, out of the gate, the type of people who joined the Bureau were just very, very, very aggressive. So that single director structure really led to that from the beginning. Hopefully, what could happen is, over time, if the reforms out there to put the CFPB under a bureau or a commission actually are enacted, then and there is attrition of these true believers from the CFPB, then the other outcome might be, well, reasonable people say, hey, this is actually going to turn out to be a mature financial regulatory agency. This actually, there's less of a chance now that if I join, I'm going to get riffed I'm going to get terminated without cause. And so there's the potential that this could end up working out really well for the Bureau, and it does become like a more mature financial regulatory agency like the OCC or FDIC. You know, I used to work at the FDIC, and I have to say, the people there, both on the supervisory staff and the legal staff, were just amazing, and they wanted to get the right answer, and just really smart, hardworking people. And I really do hope that the CFPB someday turns into that, and it's possible after all this turmoil that it does if the right reforms are enacted.
So, Peter, Loretta, we haven't heard from you yet. What are your feelings
Sure.
on single director versus multi, board format like FDIC? Do you think that that would be a better structure in the long term?
Well, I like the buck stops here with one director. You know, that was one of the catalysts for having a single director, accountability. But I do think it makes it more political and polarizing, which we've seen. And, you know, Rich just let us hear that from the inside, which to me is what Brian was digging for and what's really interesting. You know, the federal agencies have a lot of career folks, and that really helps keep a stable mission, stable messaging. It's more balanced as far as protecting consumers while listening to industry concerns to have healthy markets. And so I do believe that if we didn't have a single director, we'd have more stability and moderation, and um, less concern about career folks joining the Bureau or sticking with the Bureau. Or some of the folks I've talked to who used to be there would get frustrated if their goals or missions weren't heard or adopted. And it has led to these swings in employment and swings in positions. So I think it would add to stability and a more balanced approach to these important issues.
Yeah, I agree with Loretta. I think that the commission structure, like we saw with the abusiveness standard, that still sort of doesn't have a definition, but you saw swings back and forth on it based on who the president was and who the single director was. And especially now that, the court ruled that the director can be removable for cause, it's become an entirely politicized bureau. And so you need, I think, political buy-in from both parties to allow it to develop into a mature regulator. So a commission structure, you look at the other agencies that have those, no one's suggesting in the Trump administration that they be deleted. And I think it's because the Bureau became so aligned, in the political environment with the Democratic Party.
Well, also, now 3 concurrent back-to-back 4-year administrations, single-term administrations, does not help. We know how the CFPB agendas are lined up. The first year is a warm-up. The second year, they're still kind of finding themselves. Year 3, you get the actual real agenda set. And year 4, that agenda gets thrown out if the administration gets thrown out. We saw that under the Kraninger administration, right? It feels like just after they got through the appointments and finally got warmed up, we got MLO comp on the table. We started getting this stuff on the negotiating table and getting it on the agenda. The administration gets wiped out. We wind up with a new head. So it's definitely interesting. I definitely recommend agree with that it would help mature the department. Now back to the main point before we move on to the next topic. Where do we think that we're going to wind up? Are we going to wind up? We know it can't be a skeleton crew, because that looks like when the new administration came in, it looked like they were going for 5 guys in the back room of the White House, right? And that was going to be the CFPB. I mean, it was in Washington last week, and they ripped the name off the front of the parking garage building. It's not there, and it used to be across the street from the White House. So it looked like they were getting returning the lease back. But we now know what the statutory requirements and what the court ruling is. We need to have people in place. So what's the final word on this topic on what's staffing going to look like? Is it going to be large, medium, small? Where are you going to sit?
Matt,
Brian,
if I can just maybe start with your last question and,
Sure.
and proceed, because this idea of a commission, while it's really it's a pretty balanced way to approach the concept of an independent agency. And what I think it does in terms of a culture within the agency is it forces the staff to have to appeal to, moderation. I have to please 5 bosses instead of just one, and I don't have to just feed the sort of preconceived ideas that this one boss already has. So conceptually, it seems to be a much more moderating and compromise-inducing kind of model. One of the things we have to think about, though, is what is going to happen to independent agencies. If you look at this whole the trend within the Supreme Court's approach to administrative law, you know, for our non-lawyer listeners, I mean, the case of Humphrey's executor, I think, is likely to be teed up at some point here in the next term or two terms. And I'm not sure that the entire concept of the president appointing, you know, three people from his own party and two from the minority party. It seems like this president wants to take the position, I can appoint whoever I want. I can fire and hire whoever I want. And I'm not sure how that's going to play out at the Supreme Court. But I think it will play out at the Supreme Court. So we've got that issue to kind of address within the entire concept of an independent agency. And then you can start to say, well, where does the CFPB end up in all of this? Like, what is the role of this consumer federal regulator and how will they operate? I think it's very unclear right now. I mean, I think the stated goal of the current people in charge is to get rid of it, to do.
And you have legislative roadblocks, but don't forget, we already
Absolutely.
started talking about
Right.
midterms. If they wind up with a supermajority, I mean, that's a long shot, but if they do, you can start seeing, you know, just clear wipeouts of federal agencies entirety because they could, you know, arbitrarily adjust the statute.
It isn't the sort of the more likely scenario that you know, that we end up with court contests over what is constitutional, what is
Yeah.
required by the statutes that delay things. Perhaps we have midterm elections by the time these court cases are resolved that upset that apple cart and the ability to control the situation, and we end up getting sort of whipsawed much worse than we ever were in the prior structure. I'm very nervous about where things. I mean, you know, and you could throw in what's going to happen with Fannie and Freddie. I have no crystal ball on this, other than, you know, the sort of Clubber Lang prediction for the fight.
Yeah.
Dean.
But Brian, you're
Brian.
absolutely right. We were talking about one of the major reforms that's been floated for the Bureau is to put under a border commission. But the whole idea of having a border commission where the members can only be fired with cause by the president could be thrown out of the window. So then you have a border commission, but if they don't do what the administration wants, what the White House, whichever party has the White House during that term wants, then you know, based on what happens at the Supreme Court, you know, to Humphrey's executor, the president could potentially, you know, if the Supreme Court goes that way, have the ability to fire even the members of these supposedly independent boards or commissions without cause. And so that essentially becomes just a regular executive agency with five bosses. And, you know, all the moderation that we were talking about that might happen would be thrown out of the window. So, you know, I do think though, if the idea of an independent board or commission that can only be fired with cause remains, if the Supreme Court does keep that in place when they do get that issue, then that could be a benefit to the CFPB. Another thing that Congress could do to kind of rein in the CFPB is to actually do legislation and limit the CFPB's regulatory powers, right? So in every statute that our industry deals with, TILA, RESPA, even just provisions of Dodd-Frank itself, the CFPB has what appears to be just completely unfettered regulatory authority, discretionary authority to just go out and do whatever rule that comes to mind. That's how the servicing rules loss mitigation provisions were born. It wasn't by statute. It was just the CFPB during that time under Cordray saying, hey, we should have loss mitigation provisions again after the Great Recession, and then using this general rulemaking authority, which essentially tells the Bureau you can issue any rule that you believe furthers the purpose of the statute. And CFPB just created out of thin air. Now, Congress could go in and say, okay, CFPB, we're getting rid of all of that discretionary authority. You can only issue rules to implement specific statutory provisions that we have in place. that would go a long way to reining in these excesses, like we saw at the end of the Chopra leadership of the Bureau, where he was issuing a new discretionary rule literally almost every day. That wouldn't be able to happen if that legislation occurred. But again, that would require Congress to actually do something, which is really, you can never rely on that, unfortunately.
So if the Supreme Court findings do rule in favor of, we'll call it unfettered executive authority, we're pretty much looking at a really big game of The Apprentice, just that television show. We're going to be watching controlling the mortgage industry and our financial
Right.
services.
Yeah. You do something that the administration doesn't like, and you're fired, basically. If they get rid of Humphrey's executor, and the president can fire even, board or commission members that are supposedly independent without cause. The same thing happened, like in
Now, the Fed would be outside of that, correct?
Well, that's the elephant in the room, really, is that it's hard to have a limiting principle that, every other agency except the Fed is somehow special and independent. If the Supreme Court gets that, they might just not be willing to take that step and come up with some sort of like
So I have actually
distinction.
commented on that particular issue in one of my musings. When the CFPB funding case came out, and they addressed the funding case. Now, you remember, it was a 7-2 opinion with Thomas writing for the majority. I mean, I don't know. They could have decided that one either way on sort of the history element, but they decided it in favor that this was a constitutional appropriation of funds. And there was a footnote in the Alito dissent, which was joined by Gorsuch, who is famous for, kind of being a I don't care if it blows it all up kind of judge. I'm going to live by the Constitution. Who they basically said, yeah, we don't want to talk about the Federal Reserve in a footnote. So, and they said basically that the Federal Reserve is sanctioned by history. Well, sanctioned by, as I said in the musing, sanctioned by history would be a good name for a law school moot court team, but it's not really a good legal argument for a textualist or for an originalist. Sanctioned by history is judge-made law. So I think what that tells me is this Supreme Court is simply not going to go that far in terms of blowing it all up because it's not in the Constitution directly. They have their limits. They think that there is a role for administrative agencies. There's certainly a role for the Fed, and they don't want to be the ones to destroy that to allow a unitary executive to run roughshod on the country. That's my hope. That's my read, but who knows?
So final question of the topic is, what does the scale of the agency look like for the remainder of the second Trump administration? Small, medium, large?
So we'll probably see, at least as reported from reported statements by Senator Tim Scott, the chairman of the Senate Bank Committee, we'll probably see a full Senate vote on the Jonathan McKernan nomination in the next month or two. So it could be as early as May that we have a permanent director of the CFPB. And based on the nomination hearing and his statements during that, where he said he believed in following the rule of law and operating the CFPB to perform its statutory functions. It seems like at least his take appears to be different from the current acting director, that wanted to have, like you said, 5 guys in a back room, and no office. So I think that we could. But although he did say during the nomination hearing and in, I think, documents afterwards, that he wanted to right size the Bureau, which I think means get rid of some staff, because they do have a lot of staff currently, and maybe not all of them are necessary to perform the CFPB's functions. So I would say medium size. Now, also keep in mind during the court case, it came out in filings that the CFPB has already terminated its regional office leases and is still working to terminate the lease on the headquarters building. So I think one question will be when he becomes permanent director of the Bureau, will they actually have an office? That's I think an important question for a director of an agency. So there'll probably be some work to just kind of restart the Bureau. I do have to say though, and I should have mentioned this before when we were talking about what the Bureau is currently doing. I have actually gotten at least one regulatory inquiry answered by a regs attorney at the CFPB. So I know that they're doing something. And so there is some work currently being done, which is a positive thing. I think when they have permanent leadership and more direction, even if they turn out to be a medium-sized bureau, I think that this new permanent director, McKernan, will still operate the bureau based on his statements to be, an agency that's actually doing the things it's supposed to, performing examinations, responding to regulatory inquiries and dealing with the public on their consumer complaints and all those other functions that actually do need people. So I think it'll be a medium-sized bureau.
Well, I just saw someone famous pop into the chat. Mark McCardle just popped in the chat. One of my favorite previous CFPB post employees, and he said regs is fully up and running now. So thank you for that commentary, Mark.
So, Rich, I want to talk to you about shifting gears, Matt, if you don't mind, to the fair lending topic. I'm really curious. I mean, one of the things the CFPB did do was they filed a motion to vacate the Townstone settlement
Right.
in the Seventh Circuit. Obviously, you worked on that case.
Still work on it. Yeah.
That is just completely unprecedented. What's going on there?
Completely unprecedented. And I think that shows that there are people that are doing some things. And, with the efforts to, what at least what looked like to dismantle the Bureau in the early days of acting Director Vought's term, I think one of the things I was concerned about and others were concerned about, that a lot of positive things that the leadership could have done to engage in an era of regulatory reform and kind of put enforcement and supervision on the right path. We're concerned that it wasn't being done, but with this joint motion to vacate the Townstone settlement, it looks like I think the public can see that there are people at the Bureau who are trying to right the ship, and so they, as you can tell from the declaration, I'm not saying anything that isn't public. They looked at the investigation of Townstone, which I worked on, so I can't say anything that is confidential. But they looked at the investigation and found what I thought all along, which is that Townstone was targeted for its political speech. They even described it in the investigation documents, the Townstone podcast. And I know we've talked about the Townstone case before, so I won't get into the details and put everyone to sleep again after talking about the CFPB court cases. But the CFPB described the Townstone radio show and podcast as overtly political, i.e., it's political speech, which is fully protected under the First Amendment. But the investigation documents said, but they found that the comments were insensitive and just described them as such. They just didn't like the statements that were made. And then, but another statement in the investigation documents showed, and this is, I'm paraphrasing, not direct quote, but essentially, the investigation documents said that they didn't find any evidence of discrimination, and any discrepancy in the data could be caused by just essentially where Townstone had been marketing, and that Townstone was actually making efforts to essentially market to a diverse audience. They had diverse staff. They were pushing for down payment assistance programs and other programs that were geared towards first-time homebuyers. And so essentially the investigation documents found that Townstone wasn't intentionally discriminating, but the case that they made to the director of the agency was the exact opposite, that Townstone was intentionally discriminating. So there was something wrong there. It's a disconnect between what the staff was finding in their investigation and what they were telling the director at the time.
Well, I want to circle back to sort of implications for fair lending compliance going forward. But there's one thing I want to ask you about, and I want to be really careful that you don't reveal anything that you are not supposed to reveal as counsel. But one of the allegations in that order, or that motion to vacate, was that the CFPB director, had been misled by the enforcement staff. And what I'm wondering, and I'm very curious to know, is where are the receipts on that? How was the director of the CFPB misled by the enforcement staff? Like what documentation of that? Because that's a very, very serious allegation of sort of insubordination, deep state stuff. I don't know what you want to call it, but it's pretty bad to mislead your boss about what's going on in the case. So can you share anything? And again, I really don't want you to share anything that you can't share, but what can you share?
Right. I would encourage everyone to read the declaration for themselves. It's on the court docket. It's public, and it does describe that. And I can't say anything more than that. But I agree with you. That is really problematic. I'll also, I think it's worth I'll mention it. I think it's worth mentioning that the case was filed by former Director Kreninger, a Trump appointee. But remember, she did not have any consumer finance experience when she took the helm of the CFPB. So I think it was without having any subject matter experience, and not just in fair lending, but in consumer finance at all, it probably she was reliant on the staff. I mean, you have to be as a head of an agency, and you don't have any experience with the subject matter. And so and I think that's an important point to remind our listeners. And so when the case was going through the investigation, I suspected all along that the leadership, during the Kreninger term really wasn't. I suspected. I'm just talking about what I suspected during the time, not actually giving any inside information on what happened. But I suspected that that the leadership wasn't being given the true picture of what was going on. Because, for example, when I led the TRID role, I did a lot of consumer testing, and I understood the power of consumer testing. So what I did for the Townstone investigation was take the statements cited by the CFPB, find a consumer testing firm to go and test them with actual African American residents in the South Side of Chicago, which that was the MSA that was the subject of the CFPB's case. And we tested the statements with those residents, and they all came back with the opposite of what the CFPB alleged, which was the statements actually encouraged them, and specifically encouraged them to apply to Townstone. The participants were saying things like, "Wow, Townstone really understands our neighborhood. The owner of Townstone could really help me find a place. He knows the area. Oh, they're really funny. I want to apply to them." And at least one participant asked for Townstone's contact information on the spot. And we told the CFPB that during the investigation, and there's direct evidence that they were wrong. And if you read the declaration, it talks about that, how that was basically not really meaningfully considered by the Bureau during the time. And so it's unfortunate, but it really does show that I think the effort of the CFPB staff, the enforcement staff, and I think some of the staff in the Fair Lending Office there as well, was to basically go after Townstone and its owner. And remember, they sued the owner of Townstone personally. So they personally brought him into the case. They've never done that for a fair lending case before, but they just didn't like this guy because of his political statements on the radio. Even in the declaration, when they describe the radio show, they make the point to say in their investigation documents that the radio show is often highly critical of the Bureau. So I think what it shows is government gone wrong. They don't like what you're saying about the people in the agency didn't like what he was saying, and so they decided to sue him personally. It just really just comes across that way from the declaration as really problematic, and that's why at the beginning of of our discussion, I mentioned that the regs office people are great. And thank you, Mark McCardle, for mentioning that Regs is fully up and running. That's great info. But I think my experience on the Townstone case and in other cases I've worked on where I've had to deal with the enforcement office, I found the enforcement attorneys to just be incredibly aggressive, not really caring about the rule of law or what the right answer is under the law, but just out to get their guy. And I think that's unfortunately what's given the CFPB such a black eye, and why I think it's actually a good thing that we have current leadership really looking and looking at what the CFPB had done under past administrations, because I think that there are a lot of wrongs that happened, and hopefully those wrongs can be righted like they have been in Townstone.
Yeah, I think it's unfortunate that the manner in which this culture is going to be changed. But I think you're making the case for it certainly did need to be changed. The the nature of the way enforcement was handled.
Yeah, I mean,
It's
I totally
problematic.
agree with that. I feel like the Bureau sort of got into the role and saw itself as, the entity that's supposed to sort of reorder the, consumer finance market and the mortgage market to be more equitable and less about actually protecting consumers from actual harms. And that's why I think, McKernan highlighted that fact in his confirmation hearing. And so that's my hope, is that, once he right sizes the Bureau, that we can actually, target those actual legitimate consumer harms, because there are bad actors within our industry, and I think it would be very unfortunate if the Bureau just suspended all operations and sort of gave people a free pass to feel that they could commit fraud without any kind of consequences.
That's right.
Right.
Well, we don't
That's
have
a
a
great
lot of
point.
time here left, but I want to make sure that, Rich, you have a chance to at least give some guidance on fair lending going forward.
Right. Just to reiterate one of Peter's points, I think that seems to be what the current leadership is going to focus on, and hopefully the permanent director does too. In their last announcement, I think it was on Friday or just actually on Monday, I can't remember what day it was. Very recently, they announced that they weren't going to enforce the non-bank registry rule, which is a crazy rule that requires a non-bank entities to register and give information on their already public settlement agreements with with regulatory agencies. Just a crazy, superfluous rule that provides no benefits, and it's just intended to create liability for industry. And the current leadership said they're not going to enforce the rule, and they're going to focus on actual harms to consumers, essentially. And so that's a
They just
sign.
they just had to make a call to CSBS, and CSBS would have been like, yeah, we already have that, right? Like, it's called the NMLS public disclosure. It's a consent order, but
Right. Right. And they make the statement in the press release that we're actually going to focus on, I think I'm paraphrasing here, but like we're going to focus on real harms to consumers. But that's what the former, and I think every democratically appointed director of the CFPB wasn't doing. I mean, they were going after aggressive legal theories, trying to expand the jurisdiction of the Bureau and expand the scope of statutes, rather than just going after real harms to consumers. I mean, there are enough bad actors, low-hanging fruit cases to take, but the democratically appointed directors of the Bureau didn't want those cases. They wanted the big sexy headlines for gazillion-dollar penalties, and very interesting, sexy legal theories, instead of just going after bad actors. And I think that's also one of the problems that hopefully the new permanent director will right as well, because there are enough bad actors in the marketplace that you don't need to try and create these new legal theories like this whole, and back to fair lending compliance. So this is a good segue, Brian, to your question about fair lending compliance. There's a whole redlining theory, or as the Bureau and DOJ were calling it, modern day redlining, which I like to call it marketing discrimination, because that's really all it is. It's focusing on where a lender is marketing and not how they're actually treating actual consumers or applicants. That whole theory is made up. It was made up in the 90s by DOJ and been used by banking agencies and CFPB since. And Townstone was the first case where that theory was challenged, and no other entity that was subject to that theory had challenged the theory before. And we did get a good decision out of the district court, but unfortunately the Seventh Circuit had a bad decision, and you can read my blog post or just, look for reporting on the case to see what I'm talking about. But the Seventh Circuit had a really bad decision on the case. But I think that legal theory is really ripe for challenge because it's not in the statute, it's not in the regulations, it's completely made up. Unfortunately, though, while it's still being used, potentially it could be used by state agencies and private plaintiffs like consumer advocacy groups and other private plaintiffs. I think, unfortunately, lenders should still focus on redlining compliance. So doing, hum to peer analyses and looking at marketing target where marketing is being targeted and I think that that's one area where despite the change in administration, there could still be liability there based on state regulators and private plaintiffs. So it's still worth looking at fair lending compliance.
Well, I know that, from being in the position of leading a independent mortgage banker, it's on all of our minds. Before the current administration, we were gearing up to do as much underserved marketing as possible. And I haven't steered away from that narrative. That, I'm informing my compliance teams that we have to focus on making sure that certain underserved areas of our coverage states are getting intentional marketing. And, one thing, Rich, is we have to keep in mind here, and this is a good input from, the other industry leaders on the call, that leverage technology. We have the ability to do simple stuff, social media advertisement, targeted click ads that cover these IP addresses in certain ranges. And regardless of the current state of the CFPB, here's a surprise, the marketing actually works and you can actually get some good business out of it too. So, continue to look at your HMDA data, like you said, continue to figure out where you're not getting traction in your business in certain underserved areas. And you might be pleasantly surprised that the marketing works and actually brings some more business in for your firm.
That's a great point. There's a lot of potential positive implications from expanding your marketing, and I think that's one sales point that a lot of the compliance people that I deal with try and use internally to encourage their organizations to do the hum to peer analysis and actually look at where their marketing reach is and their
and don't forget state compliance, right? I'm in New Jersey, and our footprint is the tri-state area. I'm in core state CRA territory. New York,
right,
just passed CRA, right? I have Massachusetts. I wouldn't be surprised if Connecticut followed, right? Just because of the absence of the CFPB, Chopra almost sent out a playbook a week before, the new administration came into effect, and the states are looking for it. This is still under state regulatory authority.
Yeah, New Jersey just had a redlining enforcement action that they had announced. I think it was the end of last year. So states are definitely looking at this.
Right. Regardless of what's going on at the federal level, you still have to be mindful of states that you're operating in and your independent state regulators.
Right.
Oh yeah, and we've heard from clients that they've had increased contact with state regulators, and the examinations that they're undergoing have become more fulsome, more document requests, more questions. So the state regulators are definitely aware that there's a vacuum at the federal level, and some are stepping in to fill that.
All right, guys, any other final commentary? Looks like Loretta dropped off because of a bad connection. Any final commentary for this week or this month's Regulation Central?
I think one important takeaway for the industry, and I alluded to this before, is that the CFPB is still on the books. The laws that we have to comply with are still on the books: TILA, RESPA, ECOA, fair housing. And without legislation to gut those laws, we're still subject to them, and those laws have private rights of action, can be enforced by state regulators. And so it isn't, just because we have a current acting leadership of the CFPB that had been apparently looking to dismantle the Bureau, I think that's probably largely on hold. We are going to have a permanent director of the Bureau coming in May, and all these laws are still on the books. So keep your foot on the gas for compliance. This isn't a time to say, hey, we're not gonna have the CFPB anymore, so we can be aggressive and forget about compliance. That should not be the takeaway from what's been going on at the CFPB for the past few months.
Peter, and then Brian finishes off.
Yeah, I'd sort of echo that, and I'd just add to Rich's point that the look back on some of these enforcement actions has been anywhere from 5 to 7 years. So I would just say plan that in 2028 you could have a Democratic administration who might come in, and if there's a big snapback and say we're going to go very hard at not just lenders but anyone in any industry that we feel was trying to take advantage of the fact that the laws weren't being enforced during the Trump administration.
Yeah, I guess, I mean, I agree with all of that, but I'll also say that there's opportunity in this market right now. There's a lot of innovation that's happening, different types of lending, different types of ways of getting borrowers into homes. And that, in the past, the CFPB was very restrictive in terms of how it would look at these things. And, AI, if you have any disparate impact with AI, that they weren't going to allow it. Listen, all the look back stuff, all the possibility for changes in administration, it's all there. You have to be aware of it. But I think if you have a really good consumer favorable story to tell about why you're doing something, if it doesn't fit into the boxes that the current regulatory regime allows, I think there's opportunities to make that work for consumers, where in the past, it would have had sort of prior review and probably a thumbs down because it didn't fit in the box. So I think those are really strong opportunities for attorneys to do what they do best, and try and protect their clients, and at the same time recognize that consumers need protection as well. So that's all I would add. But again, I totally agree that these laws are still in place. You have to comply with them. There's private rights of action. There's states that are coming after you and looking at these things and writing new laws. So do your homework.
Well, I'll leave it with this. With everything going on, I think it's buckle up, right? Enjoy the ride. And this is also why you need great legal representation. So thank you again from Polunsky Beitel Green, our leader in mortgage closing compliance documentation. So great representation there. And thank you, Rich, for joining us this month at Regulations Central. Peter and Brian, you're our anchors. You guys are always fabulous. And
anchors in a good way. Right?
Yes, anchors in a great way. Yeah, you're not weighing us down. You're keeping us nice and in.
We're not holding you back.
Not holding us back either. And I'm sure we will have tons of more updates next month as we continue to pull on this thread and see the spindle in Washington unwind. So enjoy. And I'll leave one final spot. Mortgage Triggers Bills is out. So if you're part of Mortgage Action Alliance, please go to the MBA portals, send those letters out, and let's get this Trigger Bills deal through. And that is our Regulation Central for the month. Thank you, everybody.